So now we are done with contract of sale, definition about contract of sale, goods, types of goods and other definitions. Now let's do sale versus agreement to sell. I've already given you the hint about sale and agreement to sell when we were doing the definitions of buyer and seller. In the definition we had the words agrees to buy and agrees to sell. I said agree to buy and agree to sell means they are doing it in future. And this is what brings the concept of agreement to sell. There is a concept sale which means transfer of ownership at the time of contract. When you are making a contract, you transfer the ownership there. The seller transfers the ownership to the buyer. However, in agreement to sell, there is transfer of ownership at a future date. So in sale, you transfer the ownership at that time only. When you are making the contract, the ownership is transferred there and then. However, in agreement to sell, they both agree to transfer it in future. I gave you the example. There were two persons, let's say A and B. A told B that I want to purchase your bike. So B gives him his bike and A in return pays him 20,000 rupees. Now if this transaction is happening now, this will be called as sale. However, these two parties do it at a later date. Let's say after 30 days, both A and B do it after 30 days. So this will be called as agreement to sell. This is agreement to sell. You can see that the ownership is getting transferred after 30 days. This is very important. At a future date. At a future date. Here at the time of contract. The ownership is transferred at the time of contract, and in case of agreement to sell, the ownership is transferred at a future date. So this is the basic difference between these two. Okay, now let's see what is the difference between the two. What are the distinguishing factors? The first factor is ownership. In case of sale, the buyer has the ownership because the ownership has been transferred. However, in agreement to sell, the ownership will be transferred at a future date. So who is currently owning the goods? Who has the ownership? The seller has the ownership. Here the buyer had the ownership. Has the ownership rather. Now that does not mean the buyer had the ownership and he retains the ownership. No. Earlier, seller had the ownership. Now since the ownership has been transferred to the buyer, buyer has become the new owner. In agreement to sell, the seller had the ownership, he has the ownership, he will transfer the ownership at a future date to the buyer. Then the buyer will become the owner. because they have agreed to sell in future, to buy in future. For seller, it is agreement to sell in future. For buyer, it is agreement to buy in future. What happens if there is a subsequent loss to the goods? Let's say, in our example, A purchased bike from B and B sold the bike to A. In case of sale, the ownership has transferred to A. A is the purchaser here, A is the buyer. So ownership has transferred to him. Please remember, risk follows ownership. So since ownership has been transferred, that means risk also has been transferred. So any subsequent loss to the goods, any subsequent risk of loss to the goods will be borne by that person only. So in case of sale, the ownership has been transferred, that means the risk has been transferred. So now there is a loss to the goods. Who will bear it? The buyer will bear it. Subsequent loss borne by buyer, and in this case the ownership has not yet been transferred. The ownership is with the seller, so he will bear the loss to the goods. Okay, let's say A and B entered into a contract today to sell the bike after 30 days. Now on the 5th day there was an accident with that bike. So now who will bear the loss? Please remember that the ownership in the bike was to be transferred after 30 days. So seller is the owner now. He has not yet transferred the ownership. He is the owner. Risk is always with the owner. Risk follows ownership. So who will bear the loss? The seller himself. However, in case of sale, the ownership has been transferred. So even though there is some loss to the bike, who will bear it? The buyer. Okay. What is the nature of contract? This is an executed contract. This is an executory contract. Here the ownership has been transferred. Here the ownership remains to be transferred. So since here the ownership has been transferred, it is an executed. Here the ownership remains to be transferred, it is an executory. What happens if the seller breaches the contract? If the seller breaches the contract, the buyer can ask for goods as well as damages. Let's say the ownership has been transferred by the seller to the buyer, but the possession of the goods was not given. The seller told the buyer that he'll deliver the goods after 2 days. Please remember there's a difference between these two things. Selling the goods after 2 days and selling the goods today and delivering them after 2 days, these both are different. In first case, the ownership will be transferred after 2 days. In the second case, the ownership is transferred today, only the possession will be transferred after 2 days. So let's say the goods have been sold by the seller, only the delivery of the goods is pending. This might happen many times when you go to a shop, the shopkeeper tells you I'll deliver the goods. When you go to purchase some furniture, the shop wala tells you that I'll deliver the goods to your place. When you go to purchase electronics, let's say a washing machine, a TV, or a refrigerator, the shop guy tells you I'll deliver the goods. He tears, he gives you an invoice, he gives you the bill. That means the ownership has been transferred to you, only the delivery remains to be done. So till the time delivery is not done, in whose possession are the goods? The goods are in the possession of the seller. which are owned by the buyer. So let's say after selling the goods, the seller does not deliver. What can the buyer do? What is the remedy with the buyer? The buyer can ask for the goods as well as for the losses that he would incur. Let's say he was to sell the goods to the buyer, to some other buyer, to his buyer at a profit, or he was to sell the goods, and now that buyer has refused because the seller did not give him the delivery. Now the price has gone down. So whatever loss he has incurred, he can recover that also. First, he can recover the goods. Second, he can recover the loss also. In this case, you should understand that goods never belong to the buyer. The ownership will be transferred at a future date. So is the buyer the owner of the goods? No, he is not. So can he ask the goods? No, he cannot. Sorry. The ownership was to be transferred at a future date. So buyer would become the owner at that date. So before that date, the seller breaches the contract. The seller tells him, boss, I'll not supply you the goods. So in this case, the buyer cannot ask the goods. He can only ask for the losses that he has incurred because of this breach. What if the buyer breaches the contract? If the buyer breaches the contract, if he is the person who has breached the seller, this is for the buyer. What is the remedy with the buyer? And this is the remedy for the seller. What can the seller do? Seller here can only claim the price, because who's the owner of the goods? The owner is the buyer. The contract of sale has happened. The ownership has been transferred. So the buyer is the owner. Now seller cannot ask the goods back. He can only put a case on the buyer. He can only sue the buyer for the price. However, in agreement to sell, if the buyer breaches the contract, look, buyer here was never the owner. He was to become an owner on a future date. So he's not the owner. Now he has breached the contract. So can the seller ask for the goods back? No, because he is not the owner. Seller himself is the owner. He has the goods. They have not yet been transferred to the buyer. So he can only claim damages. Whatever losses the seller has incurred because of this breach by the buyer, he can only claim that. Because sale was not executed here. The transfer of ownership was not executed. So he cannot claim the price. In case of sale, if the ownership is transferred, he'll have to give the goods to the buyer and then he can claim the price. However, in case of agreement to sell, now since the buyer has breached the contract, he need not transfer the ownership and he can claim only the damages.